Good morning, everybody. Good afternoon. Good afternoon, everybody. Just let me know quickly if I am properly visible and audible to all of you so that we can start our today's revision series. Good morning, people. It's basically afternoon. Good afternoon, everybody. Good afternoon. Just let me know quickly if I am properly visible and audible in the chat box. A lot of people have joined. Okay. Good afternoon, Mehboobi, Palak, Archie, Sonia, Shikha, Arya, Chandan, Shashank, Pinky. Good afternoon. How are we all? How are we all? And how is the preparation for your June attempt going on? I am hoping that your preparation is going really well. Good afternoon, Prerna, Sushan. Okay, great. So, as you all know, that this is going to be a power pack SBEC revision. And first, let me explain you the flow of this revision series. How will we flow, and what will be the sequence in which we will cover all the chapters. So, as you all know, that your SBEC syllabus is divided into three parts: Part A, Part B, and Part C. Part A is for 40 marks. Part B is for sorry. Part A is for 40 marks. Part B is for 35 marks, and Part C is for your 25 marks. So first we will cover our Part A revision because Part A is bit lengthy and for 40 marks. So first we'll cover our Part A, and then we'll cover our most important part, which is Part C. I know Part C is the most important and we should cover it first. But you know what? Part A is very lengthy. And if we'll do Part C first now, we'll be very reluctant to do the Part A. So that is why I have decided that first we will do the revision of Part A. Part A we will cover because there are small chapter and easy. It's just lengthy. Otherwise, Part A is easy. It covers basically Companies Act. So Part A is like your Companies Act. So first we will cover your 40 marks part A, and after that we'll continue with your part C, which is like a laddu for you. 25 marks and only this much content. Three chapters you have to study: dormant company striking off and CIRP insolvency. So, and at last we will do the part B. Don't worry about part B. Although people are like very they get very bored while studying part B. कितने सारे process पढ़ने, you have to study this many process, this many acts. But we will study in a very selective manner, and we will study with a short note so that part B will also be covered in the very easiest manner. Don't worry, we will take like hardly 4 days, hardly 3 to 4 days for your part B, 2 days, 2 to 2 days for approx your part C, and we can say like 6 to 7 days for your part A. So I am assuming that since we'll study like 2 hours, just 2 hours a day, so we'll be able to complete it in like next 10 to 12 days. Okay, next 10 to 12 days we can complete your whole SBEC revision very properly, and you know it will not take much efforts. Why? Because you have to give just 2 hours of your 24 hours. So you have to give just 2 hours a day, and in just next 10 days we'll be done with our SBEC revision properly, very properly. So I wanna know how's the Josh of you all. Please give me a thumbs up in the chat box if your Josh is really high and we are good to start with our SBEC revision. Good afternoon, Pranita, Pavan, Ankush. Nikhil, Sonia, don't worry. I will provide the notes. If you are a Yesha student, then you might already have this notes. And if you are not a Yesha student, then I will make some arrangement for notes. Great. Everybody Joes is really high. Great, great. ऐसा गर्मी में पसीने तो नहीं छूट रहे ना? You're not worried about the summer. Trisha is giving thumbs up. Great, great, great. So once I'll start with the revision, I might not look at the chat box because the flow will get disturbed. So I might not look at the comments or the doubts in the middle of the revision. Once I'll be done with the revision, after that I'll take up your doubts, and after that I'll look at the chat box. So once I'll start with the revision, then I might not look at the chat box very properly. So focus on the revision part. Right. So first we'll revise our part A. Your chapter number 1 is very laddu. Your chapter number 1 of your part A talks about choice of business organization, and there is only one major question in this chapter. That question is, what are the factors which affect the choice of business organization? So this will be covered in like next 5 to 10 minutes. Next 10 minutes here this question will be covered in a very easy manner. This chapter will be completed. So first question is, what are the factors which are to be considered for choosing a business organization? Number one, your nature of business activity. Don't you think if your business activity is like on a small scale, you want to start a small trading, like I want to start one small dosha shop. So what I'll prefer, sole proprietorship. So if you want to start a small trading business on a small scale, you will prefer sole proprietorship. If you want to start your business on a middle scale, on a modest scale, not very large, not very small, like manufacturing, hotel, financing, you will prefer partnership. And if you want to start any service sector industry, like you want to start your professional service, like I want to start my CA office, CS office, that I will prefer LLP. For any service industry, LLP is prefer. And for any large scale business like multiple shops or industrial activity or super bazaars, people prefer the company form of business. So I am assuming that you know what is sole proprietorship, what is partnership, what is LLP, what is company. Next is scale. Again, very easy. Like you will decide if you want to operate on a small scale, you will prefer sole proprietorship. If you want to operate on a modest scale, you might prefer partnership or LLP. If you want to work on a large scale, then you will prefer company. This definition of MSME will be covered in the MSME chapter also, in that labor law part B. So next is capital requirement. If your business has a small investment requirement, then you will prefer sole proprietorship or OPC, because in that there is only one person. If your investment, that no money which is to be put up in the business, is on the modest scale, then you will prefer partnership or LLP. And if you require large investment, you require public money, then you will prefer forming company. Managerial ability, very easy. Let's say you don't need any expertise, any proper managerial ability, you will prefer sole proprietorship. And if you want specialization in a specific area, you will prefer partnership or LLP, because in the partnership there are different partners, so they are particularly specialized in different specific areas. However, if you need professional management, then you will prefer company. Very easy. Control and management, you know, in case of sole proprietorship OPC, control management is with a single person. However, in case of partnership LLP, it is jointly shared by the partners. In case of company, there is a separation of ownership management. Management is different, ownership is different. Owners are known as shareholders. Management is the basically board of directors. Risk and liability. In case of sole proprietorship, there is unlimited liability. In case of partnership also, there is unlimited liability. In case of company or LLP, there is limited liability. Stability of business, perpetual succession. Sole proprietorship, it is not very stable. The moment the owner will die, the business will die. In case of partnership, it is also unstable, because when all the partner dies, the partnership also dies. But in case of company or LLP, it's very stable. Why? Because of the separate legal entity, because of the perpetual succession. Members may come and members may go, but the company goes on forever. Next is flexibility of administration. So in case of sole proprietorship, there is very flexible structure, because there is much not government interference or the government rules and regulation. Not much act is applicable. They are free to change their structure and free to operate. But in case of company LLP, their structure is very rigid. It's not very easy. Whenever you want to change anything, you have to take the government approval, ROC approval, you have to inform ROC. So the company and LLP structure is very rigid, because they are properly regulated by Act, that is Companies Act, LLP Act. Division of profit, very easy. In case of sole proprietorship, all the profits are in one pocket. In case of partnership, it is shared among partners. In case of company, it is distributed to the shareholder, which is in the form of dividend. Cost, procedure and government regulation. So don't you think that sole proprietorship is not very much regulated by the government? Government don't care about the sole proprietorship. It is easiest, cheapest, no government regulation. In case of partnership, there is some regulation, however, not much, because it can be oral or written. There is not much government regulation. However, in case of company or LLP, there is so much government regulation. The compliance is very much expensive. The incorporation process is very much expensive. So this is the point. Tax implication. As you all know that you might have studied in the tax subject also, that for the sole proprietorship HUF, there is a proper slab rate given, and there is two regime, old regime, new regime. For partnership, it's a flat 30% tax rate. For companies, Indian companies, it's basically 30% or 25 depending upon the turnover. For foreign company, it's flat 40% tax rate. Geographical mobility. If you don't want to increase your business to the national level or the global level, then you want to operate in a local market, you will prefer the sole proprietorship or partnership. You want to expand your business to the national level, pan India level, or the even outside India global level, then you will prefer forming a company. Transfer of ownership. If you don't want transfer of ownership, you will prefer sole proprietorship, because in case of sole proprietorship, there is no transfer of ownership, there is no provision of transfer of ownership. In case of partnership, it is possible, because there can be admission or retirement of partner. In case of company, usually there is transfer of ownership, but in case of public company, it's freely transferable. In case of private company, transfer is restricted, somewhat restricted by the article. Managerial needs. Again, this is a similar point. No manager is needed, you will prefer sole proprietorship. Management may or may not be needed, you will prefer partnership LLP. But if there is a specific specialist, experts, managers are needed, you will prefer company. Sole proprietorship. So, secrecy in sole proprietorship, there is only one owner, so secrecy is maintained in sole proprietorship. In partnership, secrecy is also maintained, because one is free to choose the partners, and in case of company, secrecy is restricted, because almost all the information about the company is available in public domain. If you want to know the profits of a sole proprietorship, you cannot know, but if you want to know the profit of Reliance Industries Limited, you can know that going in the website, reading the annual report of Reliance. So in case of company, it's like available in the public domain, so there is no secrecy. Independence from government intervention. Basically, sole proprietorship, partnership don't have government intervention, but company LLP have government intervention and government restriction. Government comes in the working. So this is all about chapter number 1. See how easy it is. See how easy it is. In just in just 15 minutes, we are able to revise this whole chapter, and you don't give much more time than 15 minutes to this chapter. Even when you will see one day before exam, see it for 5 minutes, that will be okay, because there is only one question. It may or may not come. Factors affecting the choice of business organization, plus it's easy, you can write it on your own. So in just 10-15 minutes, we are done with your chapter 1 revision. We were a bit fast, because this chapter is not very important and very easy. You can read it, just this short note, and you can do it by your own also. Coming to the next chapter. Wait. Types of companies. Okay. Thank you so much, Palak. Okay. Coming to the chapter 2, types of companies. I will not take this chapter as of now. Why? Because this chapter is same in SBEC and company law as well. So I have basically covered this in the company law revision. If at the last you will request to repeat again, then I might take up this chapter at the last, chapter 2, types of companies. But basically this is done. This chapter is very easy, which talks about characteristics of a company. What is company, sir? Definition of the company given in section 2 clause 20, that a company means a company which is incorporated under Companies Act 2013 or any other previous company law. So this we studied in very detail in your company law revision also, in your regular class also. Characteristics of company, and there is only types of companies, like what is private company, what is public company, what is holding subsidy, what is government company. So this is done in the company law revision. You can watch that short company law revision lecture 1 for your concept clarity of types of companies. I will prefer going to chapter number 3, which talks about incorporation of companies. So in my study material, it's basically a separate chapter, Incorporation of Company. In your ICSI study material, this topic, Incorporation of Company, is a part of types of companies only. So this is no separate chapter. This is given in your types of companies only. So basically come to the topic Incorporation of Companies. We'll study this proper type Incorporation of Company in very detail now. Okay, great. So we will start with the incorporation process, and once we'll start, will flow like a butter. So incorporation of companies. The first section is section 3. Section 3 says that you can form a public company with minimum 7 members, a private company with minimum 2 members, and OPC with minimum 1 member. So you know the membership requirement, like OPC you need minimum 1 member, private company you need minimum 2 member, and for public company you need minimum 7 members. But when I talk about the directors, can you tell me what is the minimum requirement of director for each type of company? It's like 1, 2, 3. For OPC, minimum 1 director is required. For private company, minimum 2 director is required. For public company, minimum 3 director is required. So this is the very easy section 3, which says that you can form any of these companies, which may be either limited by shares or limited by guarantee or unlimited company. In case of company limited by shares, your liability is limited up to unpaid value of shares. In case of company limited by guarantee, your liability is limited up to the amount guaranteed in the MOA. And in case of unlimited company, your liability is unlimited. The liability of members is unlimited. Next important section is section 3A. Question might come from this section, section 3A, which talks about unlimited liability of members, which talks about if at any point of time the number of members fall below 7 in case of public company or 2 in case of private company, and this continues for next 6 months. You are given 6 months to bring your membership back up to the 7 or 2. Let's say in a private company, its membership fell to 1 only. So now within 6 months time is given to you. Within 6 months, add one more member, bring one more member, and increase your membership up to 2. And even if within 6 months you will not increase the limit to 7 or 2, then after that 6 months, member will become personally liable. So this is the exception of limited liability, that members can be held personally liable. So if the number of members fall below 7 or 2 and this continues for more than 6 months, then after that all the members who have knowledge of this fact, they will be held jointly and severally liable for all the debts of the company contracted during that time, which means that the liability of member will get unlimited. This is a small section. After that, the main section of this chapter, Incorporation of Company, is section 7, which talks about process of incorporation of a company. So how do you incorporate a company? How do you give birth to a company? First, you have to apply for the name. Whenever you give birth to a child, you think of his name. Now, what will I give him names? Salmon Bhai. So, first you have to approve the name of the company. Then you have to prepare all the documents, MOA, AOA, and so on. And after that, you have to file a form, which is web form spice plus INC 32. This is a very important form. You have to file a form spice plus, which is web form, basically a web service, and its another name is INC 32. After that, you have to fill one more form, which is Agile Pro S. Agile Pro S. Okay, so you have to fill this linked form also, and you have to attach this with the Spice Plus. After that, you have to prepare the EMOA, EAOA, which is basically INC 33 and INC 34, and then you will submit all these linked forms, Spice Plus, Agile Pro S, EMOA, EAOA. You will submit all this link form in the MCA portal of the in the MCA portal, www.mca.gov.in. In my regular class, I've showed you the website. How do you upload it? Where do you go? But it's not possible in the revision class, right? And after that, once you will upload all the documents, all the forms to the MCA portal. In the MCA portal, ROC will verify if everything is okay. ROC will check If everything is okay, and if ROC finds everything okay, then ROC will give you date of birth. ROC will give you certificate of incorporation. It's like your birth certificate. ROC will give you certificate of incorporation in the form number INC 11. Right, and from since that date, the company will come into legal existence. The company will take birth. So this is a very short process of incorporation of company. Now, when I talk about Spice Plus, you must know what are the services offered by the Spice Plus. Basically, Spice Plus is the integrated web form. Web form means there is no downloadable PDF form. You can fill it in the web itself, in the website itself. So, part A of Spice Plus is for basically the name reservation. The Spice Plus is divided into two parts, Part A and Part B. Part A is for the name reservation. Part B is for incorporation, DIN allotment. Through Part B, you can also get DIN allotment, director identification number of maximum up to 3 directors. You can get appointment of your directors of maximum 3 directors, and you can get your allotment of PAN and TAN. Permanent account number, tax deduction and collection account number, PAN and TAN. And after that, there is also one more attached form, Agile Pro S. Agile Pro S, it is attached with the Spice Plus. So these two forms are submitted together in the MCA portal. Through Agile Pro S, you get various services. What are those services? Through Agile Pro S, you can get GST registration, GST allotment, which is you will get GST number, GST identification number, which is known as GST IN. EPFO registration, ESIC registration. Remember, we studied a proper EPFO Act and ESIC Act in the labor law part. In your Part B, yes. So every employer have to get EPFO registration, ESIC registration, and if you are incorporating a company, then you don't need to apply separately to the labor department. However, you can get EPFO registration, ESIC registration free with the Agile Pro S. Next, you will also get professional tax registration, but it is available only in it is compulsory only in 3 states, Maharashtra, Karnataka and West Bengal. You can open a bank account through Agile Pro S. And lastly, you can get allotment of shops and establishment registration number. However, currently this facility is available only for those companies which are incorporating in Delhi, because currently our MCA, Ministry of Corporate Affairs, has tied up with only the Ministry of Labor of Delhi only. That is why this service is only available for the companies of Delhi as of now. Allotment of shops and establishment registration number. So all these are the services which are offered by Spice Plus and Agile Pro S. What is the procedure of applying for the name, or we can say that reservation of name? The company reserves a name for itself. So you can apply for the reservation of name in your Part A of Spice Plus. Part A of Spice Plus. But you know what? Earlier there used to be a form Run. Run means reserve unique name. It is also a web service, but now it is not used for the reservation of name. Currently, this Run service is used only for the change of name. So if I want to apply for the name of new company, then I will apply in the Part A of Spice Plus. However, I want to apply for the change of name of the existing company, then I will apply in Run, reserve unique name. How do we apply? Company will apply for the reservation of name in Part A of Spice Plus to ROC CRC. For the reservation of name for the incorporation, MC has made a separate authority which is known as ROC CRC. CRC stands for Central Registration Center. The work of Central Registration Center is only for name reservation and incorporation of company. And you know what? Company can give maximum 2 names in preference. Like we have to get the name of the company approved by the MCA, approved by the CRC, and we can give maximum 2 names in preference, and with the 1000 fees. ROC CRC will either approve the name or reject the name. In case the ROC approves the name will be valid for 20 days, which means it will be reserved only for 20 days. You have to apply for the incorporation of company within that limit of 20 days. However, if something is wrong, like let's say I am giving a name like uh, murder, uh, murder Mr. X Limited. This is the name of the company. So is this valid? No. You cannot use any unreasonable name. So in this case, ROC will reject. So in case the ROC reject, you will be allowed resubmission, and you can resubmit the Spice Plus. You can resubmit within next 15 days. However, there is one amendment. This is the recent amendment, that you can apply for the extension. That means if within 20 days you are not able to incorporate the company, you are not able to file for the incorporation of company, then you can get extension. You can get extension. So there is three time limit. So basically you can apply for the extension of 40 days. You can apply for the extension of 40 days from the date of approval, but you have to apply before the expiry of 20 days from the date of approval, which means this is the date of approval and you got 20 days timeline. You got 20 days timeline to incorporate a company. If you are not able to incorporate within 20 days, you can get next 20 days extension by paying 1000 rupees fees, which means total of 40 days. However, you want next 40 days extension, then you can do so. Yes, before the expiry of 20 days from the date of approval, you can get like next 40 days extension. 40 days extension, but in this case you have to give how much fees? You have to give 3000 fees. And there is one more point, that let's say I took 20 days extension. 20 days was the original time. I took 20 days extension. Now even after this expiry of 40 days, I am not able to incorporate, then I can get further extension before the expiry of this 40 days for the next 20 days. For next 20 days, which means total of 60 days from the date of approval, which is basically 20 plus 20 plus 20. In this case, I have to pay the fees of rupees 2000. I hope this point is clear to all of you. So this was the extension process. This was the extension process of the name approval. The next is incorporation process. Now once you get your name approved, you have to prepare various documents like MOA, AOA. You have to prepare your the office proof, office address proof. You have to get your utility bills, rent agreement, or the NOC from the owner to use the premises. You have to prepare various documents, and after that you will fill Spice Plus. And now the company has to apply to the ROC for the incorporation of company within 20 days of the name approval in your Part B of Spice Plus, which is basically INC 32. And along with the Spice Plus, you have to give all this linked form. All these are the linked forms which you have to attach in the INC 32, and you have to submit all this form together. Just like Fevicol, you have to this all forms will attach to each other through Fevicol. So what are the linked forms? EMOA, INC 33, EAOA, INC 34, Agile Pro S, INC 9, URC 1. What is INC 9 and URC 1? I will discuss it. And ROC will either approve or reject. If ROC finds everything good, ROC will approve and give the certificate of incorporation in the form number INC 11 and will allot the SIN. If ROC reject, then you will be allowed 2 resubmission of 15 days each. Maximum 30 days will be allowed for the resubmission. And along with your Spice Plus, Section 7 says that along with your Spice Plus, you have to attach certain documents in your Spice Plus. Like you have to take a declaration from the professional and directors officer employee of the company that company is complying with Provision of Companies Act. No defraud is made. The directors are not convicted. Basically, they have to give a declaration that yes, nobody has done any fraud. Everything is in compliance. So we have to take a professional declaration in the form number INC 8. Also, we have to take the declaration from subscriber to the memorandum and first director in the form number INC 9. So there are two declarations. Declaration by professional, declaration by the subscribers and first director, and the declaration by the subscriber and first director is in the form number INC 9. Apart from this, we have to give the address for correspondence What do you mean by correspondence? Correspondence means temporary address. Temporary address means, let's say the company don't have a proper registered office at the time of applying for the incorporation. So we can give a temporary address where the government can send communication. That is known as address for correspondence. Apart from that, we have to give the proof of that correspondence address, that is our, either we have to give the rent agreement or the property papers, ownership papers, etc. You have to give the utility bills. Utility bills means electricity bill, water bill, telephone bill. All these are known as utility bills, which must be of that building or of that address which you are using as the correspondence address or the registered address. And that utility bill should be in the name of owner, and it should not be older than 2 months. If you are using someone else's premises, then you have to take NOC from the owner of that premise. Also, you have to give the proof of identity and address of subscriber. Basically, you have to give na who all are your subscriber. You have to give na identity and address of subscriber, identity and address of first director, and particulars of interest of first director. That if your directors are director in any other company as well, and if your directors are partners in any other LLP as well, then you have to give their interest in any other entity or any other corporate. Also, you have to take their consent. Very important, whenever you appoint a director, you have to take his written consent in the form number DIR2. So all these three things, this number 1, 2 and 3, all these three things you have to file in the form DIR12. All these three things you have to file in the form DIR12. Along with the Spice Plus, along with INC 32. And you know what? During incorporation, you have to give 500 fees for your Spice Plus. There is 500 fees for your Spice Plus INC 32. But this 500 fees is not applicable in two cases. I practically showed you the fees inquiry in the MCA portal in our regular class, that this 500 fees is not applicable if your nominal capital means registered capital. If your registered capital is within 15 lakhs, if your registered capital is not more than 15 lakhs, then no fees will be there. Or if your company is not having share capital, then we will check the number of members, and if your number of members is up to 20, not more than 20, in that case your 500 fees will not be applicable. As I told you, that what do you mean by INC 9 or URC 1? Basically, INC 9 is the declaration by the subscriber and first director. And you know what? This INC 9, which is your declaration, that get automatically generated. Once you fill your Spice Plus and Agile Pro Asna, this INC 9 gets automatically generated, but it's not automatically generated in two situations. It's not automatically generated in two situations. Number one, if your total number of subscribers and director is more than 20, because in INC 9 there is a limit up to 20. In e-form INC 9 there is a limit of 20. You can fill details of 20, and if there are more than 20 subscriber or director, then you have to manually fill INC 9. In that case, it will not get automatically generated, or any of your subscriber or director does not have neither DIN nor PAN, because it will not be able to automatically refill the detail, because the data of the director and subscriber are collected from the DIN or from the PAN, and if they don't have DIN, they don't have PAN, then how will we automatically collect the data? In that case, INC 9 will not get automatically generated. So there is one point, that INC 9 will not get automatically generated if the total number of members or director is more than 20, and your subscriber or director don't have DIN or PAN. Just a minute, revise this, just a second. Okay. URC1, you know what? A unincorporated body can also get converted into company form of business. So if you want to convert any partnership firm or a sole proprietorship business or any society or any other entity into a company form of business, then along with Spice Plus you have to attach a form which is URC1. URC form is attached only when your partnership firm or any other unincorporated body is converting into company form of business. Then you have to attach one more form along with the Spice Plus, and that is URC1. So URC1 is submitted in case of conversion of a firm, LLP, society or any other business entity into company, and this is also linked with the Spice Plus. This is also linked with the Spice Plus. I hope this point till here it is crystal clear to all of you. What is the process of incorporation? What is the process of incorporation and what is the process of name reservation? You are crystal clear with this topic and you can write it very properly in your exam. We are almost done with your chapter 3 incorporation, almost done. A few more provisions are left. We are done with the process of incorporation. We are done with the process of name approval. Okay. You know what? There is one small point which I need to mention, that the part A of Spice Plus is for the name approval and your part B of Spice Plus is for the incorporation of company. So if you are very confident that yes, your name will get approved, you are very confident that yes, my name is very unique, my name is not identical to any name of any other company, my name is very unique, you are very confident, then you know what, you can do one thing, you can even submit part A and part B together, part A and part B together. But you know what? In case you are submitting part A and part B together, which means you made all the MOA and AOA and all the documents of the company in your name, which you thought that it will get approved. Let's say your name is XYZ Investment Limited. Let's say this is the name of the company you chose. And if in case ROC will reject this name now, then you will gone. If in case ROC reject this name, then you have to again prepare all the documents, again file part A and part B together. That's why the prudent practice is first file part A only, and after your name will get approved, finalized, after your name will get reserved, then you prepare all the other documents in that name and then you file the part B. Otherwise your money will also get wasted and your time and efforts will also get wasted and you again have to repeat all that process, right? So that is why there is option, you can either submit part A first and later on you can submit part B. However, you have one more option, that you can submit part A and part B together. I hope this point is crystal clear to all of you. There's one more point. There is this small point of MOA and AOA. Usually, this MOA and AOA is proper electronic forms. So there is EMOA, EAOA in the form number INC 33 and INC 34. So in the normal situation, you don't need to prepare a manual MOA and AOA. You don't need to prepare a manual MOA AOA. It is e-form, PDF form. You can just fill up the details in the EMOA, EAOA. So there is a specified format INC 33, INC 34. In all the normal cases, you can prepare your EMOA and EOA. However, in certain situation, you cannot prepare EMOA, EOA. In that case, you have to prepare a manual MOA, EOA and you have to get it apostilled. Like in case your subscribers are non-individual, first subscriber based on outside India. Sometimes when your some people foreigner, let's say Justin Bieber is subscribing to your memorandum, some people from outside India is subscribing, becoming shareholder of your company. In such a case, you have to get that apostille from a proper office, from the proper authority, like notary public, you get notarized now. Similarly, you have to get it apostille from the government authority. In that case, you have to prepare apostille MOAOA. In that case, you cannot prepare EMOAOA. Okay. And lastly, if the foreign national, that outside person, foreign national is your subscriber, and other than director having valid in, and that person don't have a valid in that case you can prepare EMOA AOA in case that person has a valid business visa. However, if the business visa is not available, if that foreign national don't have a valid business visa, then in that case you have to prepare a manual MOA and get it apostilled. In that case you cannot prepare EMOA and EOA. So this was the small point. And after that, if now your part is done, you have filed a proper all the documents to the ROC, and you have submitted the linked forms Spice Plus, Agile Pro S, EMOA, EAOA, INC 9, URC 1. You have submitted all the link forms. If ROC is satisfied, it will give you certificate of incorporation, which mentions the name of the company, SIN, PAN, TAN, and this is the conclusive evidence that the company is registered. So conclusive evidence means full and final evidence. And ROC will allot you SIN, corporate identity number, which is basically 21 digits alphanumeric number. 21 digits alphanumeric number. So this is the example. Now next is your section 9. Section 9 talks about your effect of registration. And this section 9 basically gives birth to a separate legal entity. Section 9 is the section which says that from the date of incorporation which is mentioned in the certificate of incorporation, the company will become a separate legal entity. The company will become a separate person. Finally, the company will get birth, and all the subscriber to the memorandum will become the member of the company. So subscriber will become member, company will become a separate body corporate having perpetual succession, capacity to contract, capacity to sue, etc. So from section 9 simply gives birth to a separate legal entity of the company from the date of incorporation which is mentioned in the certificate of incorporation. See, this is certificate of incorporation. In this, the date of incorporation is mentioned that this company is Green Ashbury Technologies Private Limited is incorporated on 17th day of February 2018. So this is the date of incorporation of the company from which finally the company gets birth. We are done with the process of incorporation. We are done with the name approval process. We are done with everything. Now there is another provision of commencement of business. There has been amendment in this in the recent time, in the 2019 2018 2019 amendment. This provision came section 10A as an amendment which talks about commencement of business. That company is incorporated, which means company has taken birth, but company cannot commence its business, or company cannot exercise its borrowing power. Exercise its borrowing power meaning company cannot take loan unless and until it comply with this two condition basically. So a company has taken a birth, a company has incorporated, but it cannot commence its business or exercise its borrowing power unless these three situations, these three condition is fulfilled. Number one, the company has to give a declaration in the form number INC 20A, which has to be verified by a CA, CS or CMA in practice, and the company has to give this declaration within 180 days from the date of incorporation to the ROC. And in that declaration they will declare that the subscriber to the memorandum have paid the value of shares which they agreed to purchase. The subscriber agreed to purchase the share, and we have to give a declaration that yes, subscriber have paid the money, they have transferred the money to the company's bank account. So we have to give this declaration within 180 days. And in case any sectoral approval is required, we shall take that sectoral approval. Also, the company has to file verification of registered office to the ROC in the form number INC 22. You know what? A company should have a registered office within 30 days of incorporation, and we have to file the particulars, the address of our registered office to the ROC, and we have to get our address of the registered office registered with the ROC. So that is why we have to file a document which is known as INC 22 for the verification of registered office to the ROC. So these three conditions should be fulfilled in order to commence your business. then only a company can commence its business or exercise borrowing power. What are the three conditions? What are the three conditions? Number one, you have to file a declaration verified by CACS CMA in within 180 days from the date of incorporation in the form number INC 20A, and company has to file a verification of registered office in the form number INC 22 to the ROC. We are done with this. Penalty you can ignore. And if you don't file INC 20A, that means you don't file a declaration INC 20A within 180 days, plus if ROC believes that the company is not carrying on business, then ROC can initiate the physical verification of that address, and ROC can initiate the removal of name of the company, which means ROC can suo moto strike off the name of the company. And you know what is strike off? We have studied in Part C. In Part C, there is a proper chapter of the strike off. There is one more provision of active. This is not there in your module, but number of times question has been asked from active. So there is this form, active form. The basically full form of this is active company tagging identification and verification. So there is this one-time limit that all the companies which were incorporated on or before 31st December 2017, they have to file the particulars of their registered office in the form number, in the E-form active, in the form number INC 22A on or before 15th June 2019. 15th June 2019. So this was a one-time requirement that all the companies have to file a particulars of their registered office. Why this logic was, what was the logic behind this? The logic was to check whether this company have an actual physical address or not, or that address is imaginary, to check the address. So along with this form, basically company had to submit a photo of the director in the registered office and outside the registered office. So this was just to check the physical address, just to check whether the company has a proper RO or not, just to check whether the company has proper registered office or not. So every company which is incorporated on or before 31st December 2017, they have to file particulars of their registered address, registered office in the E-form active, and there was a deadline mentioned before 15 June they have to file. Otherwise, that company will be marked as active non-compliant. I showed you in the MCA website that see, the company will be marked as active non-compliant, and if ROC believes that this company don't have a proper physical address, then ROC may cause physical verification, physical checking of that address. And if ROC thinks that this company don't have a proper address, then ROC will remove the name of the company. ROC will strike off the name of the company from the register of member. Two type of companies are not allowed to file active form if they have failed to file their financial statements under section 137, or they have failed to file annual return under section 92. And these companies are not required to file active. If a company is already struck off, so these companies are already died now. You don't need to file now INC 22A active form because you are not active. So, right, so these companies are not required to file active. Number one, the company which is already struck off or which is under the process of striking off, which is under the process of liquidation or which is already dissolved, and the company which is amalgamated. So basically all these are the example where company is no more into existence, the company is no more doing business. In such a case, that company is not required to file active. Very important, an active non-compliant company, which means if there is any company which has not filed active form, so that is active non-compliant, then such active non-compliant company, such defaulter company will not be allowed to file these 5 forms. Number 1, SH7, which talks about alteration of share capital. Pass 3, which talks about alteration of paid up share capital, basically allotment. This talks about allotment of securities. DIR 12, which talks about change in director. INC 22, which talks about change in registered office. INC 28, which is basically for the amalgamation demerger. However, if there is any company which did not file INC 22 within this time, 15th June 2019, but if it want to file active after 15th June 2019, then it has to pay late fees, and that late fees is 10,000. 10,000. If any company has filed before 15 June 2019, no fees is required. But if a company files active form after 16 June 2019, on or after 16 June 2019, then that company has to pay fees of rupees 10,000, and after payment of rupees 10,000 fees, that company's status will be converted back from active non-compliant to active compliant. I hope this point is crystal clear to all of you. You know what? With this, we are done with our chapter number 3, which is Incorporation of Company. Congratulations! Just let me know if you have any doubt till here, and if you are crystal clear with the process of incorporation, with the process of name approval, commencement of business, active, this chapter and chapter number 1, which was Laddu basically, choice of business organization. So just let me know quickly if we are good to proceed to next chapter. Let me know, give me a quick thumbs up in the chat box if you understood till now, if you're clear till now. Nikhil is saying yes. Archie is saying crystal clear. CCM. Okay. My South student don't know the meaning of CCM. CCM means crystal clear, ma'am. So the CCM is the shortcut of crystal clear, ma'am. Okay. Everybody is crystal clear? Rest of the people, you are just watching. Give me a thumbs up in the chat box if you are clear. Sonia is saying clear, ma'am. Great. Palak is also clear. Everybody is clear? Great. So we are good to move towards next chapter. So this is a bit fast track revision. In case you don't understand any point or you need a more detailed explanation on any particular point or any particular topic, you can message me over Telegram. I will surely explain you in detail. But this is a revision. So here, this the basic purpose is to revise all the concepts in the proper manner. So if you don't understand any point, you can just let me know in the Telegram. I will clear your doubts. Okay. So with this, we are starting with our next topic, which is basically MOA and AOA. Okay. Great. Everybody is clear. CCM. Okay. Great. So we are good to start with our next topic, which is MOA and AOA. See, the chapter 2 types of companies part. For the your revision of types of companies, you can refer lecture 1 of company law revision. So there is a company law revision lecture. You can watch lecture 1, and there all this topic of types of companies will be covered there. So that's why I'm not taking that topic. Okay, great. Chapter number 4, Memorandum and Article, very important chapter, Memorandum and Article of Association, which are basically the charter documents of the company, What is the definition of your MOA and AOA? So first I want to explain you the difference between MOA and AOA. So for understanding the difference between MOA and AOA, there is a proper chart I have made for you. This is the difference between MOA and AOA. So if I talk about MOA, then MOA is the charter or constitution of the company. Why? Because MOA defines the boundaries of the company. MOA defines the basically scope of the company, the area within which a company can operate, the what are the objects of the company, and what is the scope of the company. So MOA lays down the boundaries. So that is why MOA is the charter document of the company. MOA is also known as charter of the company, or MOA is also known as constitution of the company, which lays down the boundaries within which the company can operate, which lays down the powers of the company, what all activities a company can do, what powers a company can exercise, what is the scope of area of a company. However, if I talk about AOA are known as bylaws because it gives you internal rules and regulations. The internal rules and regulations are mentioned in your article of association. Your internal rules and regulations are mentioned in your article of association. So that is why article is known as the bylaws or rules and regulations, internal rules and regulations. So this is the basic difference between MOA and AOA. Let's say the MOA will give you these boundaries that you can operate only within these boundaries. You cannot go beyond these boundaries. This tells MOA. However, what is AOA? AOA tells you what will the process to work within these boundaries. So how will you operate within these boundaries? So what will be the rules and regulations for a company to operate within these boundaries of MOA? That rules and regulations is mentioned by AOA. I hope you are clear with the difference between MOA and AOA. Both are very important document of the company. However, AOA cannot go beyond a memorandum. Memorandum lays down the limit and AOA should be inside memorandum, which means AOA should be within the boundaries of memorandum. AOA should be within the scope of memorandum. AOA cannot go beyond memorandum. AOA cannot say anything which is not permitted by the memorandum. I hope this point is crystal clear. The basic difference between MOA and AOA, the MOA definition is given in 256, AOA definition is given in 25. The section for MOA is section 4, section for AOA is section 5. MOA is also known as the charter or constitution of the company. AOA is also known as bylaws or rules and regulations of the company. MOA lays down the powers, the objects of the company, the scope of the company within which a company should operate. AOA lays down internal rules and regulations of the company. MOA defines relationship of the company with outsider, external relation. However, AOA defines internal relation between the company and its member, internal relation. MOA is superior to AOA. You know na, I already told you that who is superior. MOA is superior or AOA is superior. In the fight of MOA and AOA, who will win? MOA will win. MOA is superior to AOA. But MOA is subordinate to Act. Act means Companies Act. If there is a fight between MOA, AOA and Companies Act, who will win? Companies Act will win. Which means MOA, AOA cannot specify anything which is against the Companies Act. So if there is inconsistency between MOA, AOA and Companies Act, who will win? Companies Act will win. Okay. But if I talk about AOA, AOA is a subordinate document or a subsidiary document which is subordinate to MOA and Companies Act both. So if I talk about ultravirus, so if you do anything, we will study the doctrine of ultravirus. Ultravirus means you cannot go beyond MOA. A company can exercise only those powers which are permitted by MOA. And in case a company does any act which is beyond the scope of MOA, then that act will be known as ultravirus and that will be void. Even all the members cannot ratify that act. Even if all the members give approval to that act, they cannot ratify that act. So, any act which is beyond the scope of MOA is ultravirus and it is void. Even all the members cannot ratify, which means cannot approve that act. However, if I talk about AOA, if any act is done beyond AOA, then it's not ultravirus. If any act is done beyond AOA, but within the power of MOA, then it will not be ultravirus, and members have power that by passing a unanimous resolution, they can approve that act. All the members can ratify that act, which means subsequently approve that act. If I talk about MOA, it's difficult to alter because central government approval is required, SR is required. In case of AOA, it's very easy to alter AOA because with just simple SR you can alter the AOA. You don't need central government approval for changing the internal rules and regulations of the company. But in order to change the name, to change the, let's say, A registered office, you need central government approval, you need government approval. So this is a very important differentiation between MOA and AOA, which is covering very important points, very important points, right? I hope this is crystal clear to all of you. So now we can further move towards the definition of MOA and AOA. The definition is very easy. What is memorandum? What is MOA? MOA, memorandum, means simply a memorandum of association of the company as originally framed or altered from time to time, which means, can you alter the MOA? Yes, we can. So as originally framed or altered means changed from time to time in pursuance to any previous company law or present Companies Act 2013. The same definition is of AOA. There are the different model, which means format prescribed in the Companies Act for MOA and AOA, and the different formats are A, B, C, D, E, F, G, H, I, J. This much. So A, B, C, D, E, F, G, H, I, J. These are the model forms of MOA and AOA. The model forms for MOA is given in section 4, and the model forms are A, B, C, D, E. It is A is for company limited by shares, B is for company limited by guarantee and not having share capital, C is for company limited by guarantee and having share capital, D is for unlimited company and not having share capital, E is for unlimited company and having share capital. Similarly, if I talk about AOA, AOA is given in section 5. In section 5, the model articles of AOA are given, that table F, which is a very important table. Table F is the model article for company limited by shares. Table F is the model article for company limited by shares. Table G is the model article for company limited by guarantee and having share capital. H is for company limited by guarantee and not having share capital. I is for unlimited company and having share capital. J is for unlimited company and not having share capital. How to remember? It's very easy. Just that you have to remember here. First there is a limited by shares, then limited by guarantee, then unlimited. Here just you have to remember that at first it is not having share capital. Then you will flow. Like not having, then having. Not having, then having. And here in article it's opposite. First having, then not having, then having, then not having. So I hope it's easy to remember this forms of MOA and AOA, which is basically a model articles. Table A, B, C, D, E and table F, G, H, I, J. Okay. Very important. The clauses of MOA. Very important. There are 6 clauses of MOA which are given in section 4. The section for MOA is section 4. And what are the contents of memorandum? What are the contents of memorandum? A memorandum have the 6 clauses which is given in section 4, clause 1. Number 1 is the name clause, which defines the name of the company, which basically ends with either limited or private limited, except section 8 company and government company. Section 8 company and government company are exempted from using the word limited or private limited. Next is situation or registered office clause, which mentions the state in which the registered office of the company is situated. Let's say if any company is situated in Bangalore, then we will only write that the registered office of the company is in Karnataka. We will only write the name of the state. Exact address is not required. Next is object clause, very important clause, which tells the object of the company. Object means what all activities a company can do, what powers a company can exercise. So all these are mentioned in the object clause. The main powers, the subsidiary or any other matters which are necessary to carry out the main object. So all this power will be included in the object clause. Next is the liability clause. Liability clause mention your liability. Capital clause, which mention that the maximum capital which a company can raise. The capital clause mention the authorized capital, the maximum capital which a company can raise. And after that there is association or subscription clause, which basically in which the subscribers undertake to purchase the shares of the company, and they sign they sign the memorandum, that is known as subscription clause or the association clause, and they mention the number of the shares which they agree to purchase, which they agree to purchase. So there are these 6 clauses of the memorandum. You have to repeat with me. Number 1, name clause. Number 2, registered office clause. Number 3, object clause. Number 4, liability clause. Number 5, capital clause. And number 6, association or subscription clause. You cannot change the sequence. This sequence, you have to, you cannot change the sequence of this MOA. Number 1 will be name clause, which means it will be name clause. You cannot say number 1 registered office clause. No, you cannot change the sequence. And in case of one person company, there is one more clause, which is succession clause, and basically succession clause is a part of this subscription clause, which tells the name of the nominee who will become the member in the event of the death of the subscriber to the memorandum. In the event of the death, okay, my pronunciation is somewhat, death of subscriber. Okay, I hope this point is crystal clear to all of you. We are done with this. Great. One small point, that all these clauses are compulsory clause. It's like I don't want to include the liability clause in my memorandum. Can I do so? No, you can't. All these clauses are compulsory clause, compulsory to be included. Now we'll study in detail each and every clauses of the memorandum. Number 1 clause is the name clause. Name clause specifies the name of the company, which basically ends with the word either private limited or limited. And you know what, there is various restriction with respect to name of the company. Your name of the company should be very proper. It should not be offensive to someone. You cannot use words like murder in your name. It should not be offensive to particular religion or offensive to the society, and your name should not be undesirable as per central government. Let's say I am using the name only, uh, let's say Portfolio Investment Limited. So what is this name? Portfolio Investment. Portfolio Investment is an activity. Use some unique name now, like Ishika Portfolio Investment Limited. Now there is some uniqueness. Portfolio investment is just indicating the activity, so that name is undesirable. So your name should not be undesirable in the opinion of central government. Your name should not be identical to any other existing company. Can I use the word Tata in my company? No. Can I use the word Reliance? Can I use the word Adani? No, I can't, because there are already existing companies in this name. So I cannot use a name which is identical or similar. Can I use the word Reebok? No. I cannot use any word which is identical to any registered trademark or to any registered company, any other existing company or any other existing LLP. Okay, so this is the point. And you know what? Sometimes central government says that if you are using any name which is showing any connection with the central government, like for example, I'm using India Investment Limited. Bro, India, it is showing the relation with your country. Let's say I'm using the government India Limited. Can I use that word in my name? No, that name is showing connection with the central government or the state government. If I'm using the word, let's say, Ministry of Corporate Affairs, can I use that name? No. Ministers India Limited, Ministers Investment Limited. Can I make that? No. So if you're using any word which is giving an impression that there's some connection with the central government or state government, then is it prohibited? No, it's not prohibited, but you have to take the prior approval of central government. But you have to take the prior approval of central government. If central government is giving you approval, then okay, then you can use. However, there are certain words or expression which are given in Rule 8. For using that word in your name, you have to take approval of central government. Ma'am, example, what kind of word? Example, like if you are using this words in your name, then you have to take approval of the central government. Example, you are using the word Prime Minister, Chief Minister in your name. You are using the word President, President's Services Limited, President's Management Services Limited. So you cannot use that. You are using the word state, You are using the word governor, the word court, judiciary, government, India, Bharat, bureau, you are using the word union, republic. These are just examples. This list is a very long list. I'm just giving you an example that if you are using this kind of words in your name, by it's not your dad's that you will use. You have to take government approval. You have to take central government approval before using all these names in the name of the company. I hope you understood this point very properly. And you know you cannot use a name which is undesirable in the opinion of central government, which is like undesirable, not very proper. And when a name is considered to be undesirable, here are some examples given. Let's say your name includes a trademark which is already registered. Trademark which is Yashas Academy, it is a registered trademark. Can anybody make a company named Yashas Academy Limited? No, they cannot. Why? Because this trademark is already registered. Offensive to any section of people. You are using any word, let's say, which is offensive to a particular category of people or a particular religion, then you cannot use that word. Your name is particular, merely descriptive means I gave you example now, like Portfolio Investment Limited. It's just showing the activity. Give some unique name to your company. And if your name is prohibited under Emblems and Name Prevention of Improper Use Act, there is a proper act made for the prevention of improper use of name. So if this kind of name are used, then they will be undesirable in the opinion of central government. Lastly, your name should not be identical to any existing company. And when a name can be said to be identical to any existing company, when a name can be said to be identical to any existing company, if the both the name are same except for the following, which means there is only difference of this, then we will ignore this difference and we will consider the name as same. Let's say if the name are same except for the words like private, like there is a company like Reliance Industries Limited. Can I form a company named Reliance Industries Private Limited? No, everything is same, there's just one word added, private. So because of this name will not be considered as different. These two names will be considered as identical. There is a change in case. This Reliance is in small case. Let's say I am writing all in capital case. Reliance. So will this be considered as a separate name? The answer is no. This will be considered as an identical name. Okay. After that, tenses. Tenses, if there is one company in the present tense, I am just changing the tense, the name of the company in the past tense. That will also be considered as identical name. I am just making singular into plural. Singular into plural. Let's say there is a company like Reliance Investment Limited and Investment Limited, and I am using the word Reliance Investments Limited. So again, it will be considered as identical. If there is a misspelling, like this is Reliance, can I make like this? This, can I use this word? No, this is misspelling. This is also considered as identical. Translation of just Hindi and English. Let's say translation. You are getting this right. If you are just translating the word English into Hindi, then that will also be considered as the identical name. So this, in this case, the two names will be considered as identical, and you will not be allowed to use that name. But you know what, there is one exception. In case you want to use the name which is identical with any existing name, then you have to take NOC from that company that I can use now. Then you can use by taking the NOC from the directors of the company. So this is the way. So this is the all about restriction on the name. There is some restrictions and prohibition on choosing the name of the company. I hope this point is crystal clear to all of you. The next is registered office clause or the situation clause. Just a minute. Are we crystal clear till here? Are we crystal clear till here? Let me know quickly. Okay, great. We are crystal clear. Great. So we can move forward. The next clause is the registered office or the situation clause, and this clause mentions the name of the state in which the company is incorporated. So basically, you know what is the section for registered office? The section for the registered office is section 12, and section 12 says that even if while applying for incorporation we don't have a proper registered office, but there is a deadline of 30 days given, that within the 30 days of incorporation you should have a proper registered office. It's okay if you don't have a registered office at the time of incorporation. You can give a temporary address, that is a correspondence address, and further you should have a proper registered office within the 30 days of incorporation. So within 30 days of incorporation, you should have a proper registered office, and you have to file a form which is INC 22 to the ROC for the verification of your registered office with the ROC. With the ROC. So company has to file, company should have a proper registered office, and also file the verification of that registered office in the form number INC 22 with the ROC within how many days? Within 30 days of the incorporation. But filing of INC 22 is not required if the company's registered office is same as the correspondence address. Remember, I told you that at the time of incorporation you have to give the temporary address, and you have to give the details of your temporary address. And if your permanent registered office is same as the correspondence address, then that address is so already registered with the ROC now, so you don't further have to file INC 22 again. So there's one small requirement, that a company has to fix its name and address outside every office, outside every place of business. So whenever you will see a big building of any proper company, you will see the name of that company and outside that building, and the address in English language and in local language. So if it's in Bangalore, so there it should be written in English and Kannada. So after that, you also have to print the name of the company, address, SIN, email address, website in all the business letters, bill heads, notices and publications. And in case there is a change of name, then you have to display your old name as well as new name, and the old name should be displayed for at least 2 years after the change. And also in your website also you have to disclose all your name, address, SIN number, telephone number, email, etc. So this was the small point about the registered office or the situation clause. This was the small point about the registered office clause or the situation clause. The next clause is the object clause. The next clause is object clause. This is a very easy, this don't need explanation at all, because I have already explained the object clause while I was explaining the difference between MOA and AOA. That in the object clause, we write our object, our scope, the activities which a company can do, which a company is permitted to do. So in the object clause, we set out all the objects and other matters which are necessary to carry out the company, all the additional activities, matters which a company can do. And this is very important clause. Why? Because this is the main clause. Object clause is the main clause of MOA, and it determines the purpose for which a company is formed, determines the object, determines the scope of the company. And if a company does anything which is not permitted by MOA, that means it will be beyond the scope of MOA. And if company does any activity which is beyond the scope of MOA, then it will be ultra-virus and void. So if company does any scope, any activity which is beyond the permitted range, then it will be considered as ultravirus and thus void. It will be considered as ultravirus and void. There are some case laws. I will not refer to all the case laws in the revision clause, just few important case laws. Few important case laws. Number one, that if there is any activity which is ancillary, or in order to carry out the main activity, you have to do some another ancillary or incidental activity also, then you are permitted to do that activity. However, what object a company can specify in its memorandum. So members are free to decide any object, whatever business they want. You want to start hotel business, okay, you can. You want to start a real estate business, okay, you can. You want to start education business, okay, you can. So company subscriber enjoy no restriction, very freedom in deciding the object. There's only one restriction, that it should not be illegal. It should not be illegal. Okay, and basically here one point is mentioned, that your memorandum is also known as your charter, because it defines the object and your object clause, how you should interpret your object clause. So it should be interpreted in such a way that to confer on the company all the powers reasonably required for the attainment of main object. As I said, for the attainment of main object, if there is any other activity needed to do, then there will be implied authority that yes, a company can do all this activity. And while reading your MOA, you should apply reasonable interpretation. Reasonable interpretation means what is the interpretation of that word or that sentence according to the intention of law, according to the dictionary meaning, according to the history of that law. Next is, this is already done. If any act is done beyond MOA, that is ultra-virus and thus void. This is already done. So all this remaining case laws will also be covered under ultra-virus topic. Next is liability clause. Liability clause. Liability clause is very easy, which specifies what will be the liability of members. There are only three options. It can be either limited by shares, or limited by guarantee, or unlimited. In case it is limited by shares, you simply have to mention that the liability of members will be limited up to unpaid value of shares. In case it is limited by guarantee, you simply have to mention that members liability will be limited up to the amount guaranteed in the MOA. And in case it is unlimited, you simply have to mention that the liability of members is unlimited. Very easy, liability clause. And lastly, there is a capital clause which mentions the authorized capital of the company. Authorized capital means maximum capital which a company can raise. Authorized capital is also known as nominal capital, registered capital, authorized capital. This is the maximum capital which a company can raise. And if a company want to increase the authorized capital, then we call it alteration of capital clause, and that is done by section 61. Section 61 we study in Companies Act, in your company law paper, where you study how to alter your capital, how to alter the capital by passing basically ordinary resolution. Ordinary resolution. You know what is subscribed capital and paid up capital? So authorized capital is like maximum capital which a company can raise. However, let's say company is allowed to raise 10 crores, but let's say company issued only 1 crore and it is subscribed by the public, then it will be the subscribed capital which is actually purchased by the company. And among 1 crore, public has paid, let's say, only 60 lakhs, 40 lakhs is not paid. So 40 lakhs will be paid up capital, and 60 lakh will be paid up capital, and 40 lakh will be unpaid capital. So paid up capital means the amount which is actually paid by the shareholders to the company. So this is a very easy and small clause which is capital clause. And lastly, there is a subscription clause, association clause. There are the two names of this clause. This clause is also known as subscription or association clause, which says that here the people, they subscribe to the memorandum, they sign the memorandum, and they promise to purchase the shares of the company once a company gets incorporated. So their name is mentioned and the number of shares which they promise to undertake which they promise to purchase is mentioned, and every subscriber must purchase at least one share, at least one share. So here they basically write this word. This sentence is literally written in the subscription clause of the MOA, that we are desirous of forming a company, and we are desirous of subscribing the shares of the company, subscribing the shares of the company, and they append their signature in the subscription clause. And in the subscription clause, each subscriber should take at least one share, and each subscriber must write opposite of their name the number of shares which they agree to take. They write their name, and in the second column they write the number of shares which they agree to purchase. In case of one person company, there is one more additional clause, which is basically succession clause. Succession clause tells you the name of the nominee, that in the event of the death of the subscriber, that nominee will become the member of the company. That nominee will become the member of the company. We are done with the clauses of MOA. Congratulations. We are done with the 6 clauses of memorandum. Congratulations. ट्रस्ट मी, इससे ज़्यादा कुछ नहीं है. दिस वी आर रेफरिंग द रेगुलर मटेरियल एज वेल एज कि कुछ छूटा तो नहीं है ना, नथिंग इज लेफ्ट ना. सो वी आर रेफरिंग ऑलमोस्ट ऑल द इम्पोर्टेंट पॉइंट्स. Palak is asking, ma'am, do we have to remember the name of the case laws? It's obviously always good to remember the name of the case laws. However, it's not very possible to, because in your SBC there are numbers of case laws. In your company law and SBC there are numbers of case laws. So it's okay if you remember the few important case laws of any topic, like like remember one case of MOA Ashbury, and remember one case of AOA. So if it's okay, you can remember one to few very landmark cases. Other cases you can ignore, because it's human mind how much you will remember. Now it's already a lot to remember in the company law tax as well. Okay, great. So now we can move forward. We can move towards the next topic, which is Article of Association. Article of Association. I have already explained what is Article of Association, and I have told you that Article of Association is subordinate to MOA. Is subordinate to MOA. Like, article only tells the internal rules and regulations. See this chart I have made during the regular class also, that if this is the boundaries which are laid by MOA, then AOA tells only the internal rules and regulations, how to operate within those boundaries. Within those boundaries, AOA is also known as bylaws, which basically tells the rules and regulations of the company, and it basically deals with the right of member and of the company interest. It gives the internal relation between the members and the company. And you know what? AOA is subordinate to MOA. I have already explained in the differentiation also that AOA is subordinate to MOA. AOA is subordinate to MOA. Great. So here one very good line is given, that memorandum is a memorandum. The memorandum is as it were the area beyond which the action cannot go. Memorandum is like area beyond which a company cannot go. However, inside that area, shareholders may make such rules and regulations as they deem fit. Inside that boundary, they can make whatever rules and regulations, but it should be within the boundaries. Within the boundaries, they can make whatever internal rules and regulations as they want. So I can say that memorandum lays down the scope and power of the company. However, article governs the ways in which those objects are to be carried out. Memorandum just define the power. Okay, company can do this. Okay, company can make investment. But article tells, okay, how a company can make investment by passing OR, by passing SR, taking which approval. So article tells the ways in which that object is to be carried out. This is a very good line, very good line. And this is the basic explanation of article of association. Article of association are not laws. Sir, article of association are not law. Is article of association law? Is article of association kanun? Is article of association law? No. Article of association is not law, and they do not have the force of law. What does this mean? This means that if any provision of the article or memorandum is contrary to any provision of the law, it will be invalid. Can you write anything in the article which is against company law? Which is against company law? Like company law says that for making loan guarantee security investment, you have to take unanimous board resolution. Unanimous means approval of all the board of directors. So can article write that for making loan guarantee security investment, we need only majority board approval? No, you can't say that. It will be against the Companies Act. So article has to be within MOA also, and article has to be within AOA also. So if I will lay down the hierarchy, how the hierarchy will be? Who is the most supreme? Act is the most supreme. Act is most supreme. Your MOA and AOA cannot go beyond Companies Act. Who is the most supreme? Companies Act is the most supreme, and your MOA and AOA cannot go beyond Companies Act. And if I talk about MOA, MOA is supreme to AOA but subordinate to the Companies Act. So MOA also cannot go beyond Act, but it is supreme to AOA. Now if I talk about AOA, AOA is subordinate to MOA and Companies Act both. AOA cannot go beyond MOA also and beyond Act also. This is given in section 6. This is given in section 6, which says that Act is supreme and Companies Act overrides MOA and AOA. So here we are done with this. See, now here various case laws are given that article is subordinate to memorandum. Article is subordinate to memorandum. So basically I have explained you the crux. I have explained you the crux. Only I'll discuss few important case laws. Number of case laws are given in your this. Almost all the case laws are covered from your ICSI study material. So here we will refer only the important case laws. Like these articles are subordinate to memorandum and to act. So if article is going beyond memorandum, then it will be ultra virus, because even article cannot go beyond memorandum. And if article is going outside the scope of MOA, then obviously it will be what? It will be ultra virus and void, non-operative. So if article is going beyond memorandum, it will be inoperative, null, void, ultra virus and incapable of ratification. That means it cannot be ratified even with the approval of all the shareholders of the company. And another point is Act is supreme, which means that if the article is against Companies Act, then Companies Act is supreme. Companies Act will have overriding effect. Here one point is mentioned that if there is ambiguity means confusion. If there is ambiguity in the memorandum, confusion in the memorandum, can you take advantage of that? And in that situation, can article go beyond memorandum? No. Even in that situation, article cannot go beyond memorandum, and rather it can be used to explain the memorandum. To explain, let's say if there is any confusion in the memorandum, any point is not given very clearly, but the article has given the procedure for that, then article can be used to explain it, but cannot go beyond the permission of MOA. So basically, these are the important points of MOA and AOA. And here one point is said that MOA is made for the benefit of outsider, for the benefit of creditors, outside public and shareholders, because the MOA governs the external relations. So MOA protects outsiders of the company. We are done with this topic. The next topic is registration of article. Registration of article means registration of MOA and AOA with ROC, registration with ROC, is it compulsory? Yes. Every company has to submit MOA and AOA along with SPICE Plus, along with incorporation documents to the ROC for registration. So yes, at the time of incorporation, it is compulsory for a company to file MOA and AOA, MOA and AOA to ROC, and it should be duly signed by all the subscribers. Duly signed by all the subscribers. And here one point is mentioned that your company can either adopt the model articles, that is table F, or you can include some additional point also. You may adopt all or any of the regulations of the model articles, which means that let's say there are 20 regulations in your table F. So you can adopt either all the model articles of table F, or you can take only some of the regulations from table F, and rather remaining you can make on your own. Right. One small point, if the table F is not expressly excluded, in that case table F will automatically get applied. So let's say my company has made its own article and we have not adopted table F, and we have also not expressly excluded the table F. In that situation, table F will automatically be applied to my company. If I expressly exclude the table F, that table F is not applicable to my company, then only table F will not be applicable. If I don't expressly exclude, in that case table F will be automatically applicable to my company. This is the small point. Very important, entrenchment provisions. Very important, entrenchment provision. Usually people get very much confused about this provision, and I don't know why. Entrenchment provision. So this is, see, this is given in section 5, which is article of association of the company, and here I have given 3 star, which is basically important. Let's make moon also. Okay, entrenchment provision. Entrenchment provision. What are the entrenchment provisions of the article? So I have to explain this. I might take 5 minutes in this topic, but I have to explain this. I can't explain this orally. I have to take example in this topic. So that's why it might take 5 minutes for this topic, but we are taking this topic because this is important. So let's understand the entrenchment provision properly. Okay, let's take example. Let's take a small example, that let's say usually a company, in order to alter the article, I want to alter my article, then what I have to do, I have to pass special resolution. Let's say in my article 10 points are mentioned. In my article, let's say this is my article of association, and here 10 points are mentioned. 1 2 3 4 5 6 7, let's say 7 points are mentioned in my article. And usually in order to alter any of the provision of the article, I have to pass special resolution. We have studied this. Yes, in order to alter the article, you have to pass special resolution, SR. But I want to make it more strict. Can I make it? Yes, you can make the article more strict, but you cannot make the article more lenient. What did I said? Please repeat, madam. I said you cannot make the article lenient, but you can make it more strict. If law is saying you have to do minimum 2 board meeting, then minimum to 2 you have to do. You want to do, you want to do 5, you can do. If law is saying you have to do minimum 4 board meeting, then minimum 4 to you have to do. And if you want to say no, I will do minimum 6 board meeting, is there any restriction? No, you are making law more strict, so you can do that. But let's say can you say that no, I will hold only 1 board meeting, I will not hold 4 board meeting. Is it okay? No, it is not okay. So it's like law is saying you to read 10 books. You are saying I will read 20 books. It's you want to take more headache, you take. But can you say that I will read only 5 books? No, because law is saying minimum 10 books, so you have to read. So that is why you can make law more strict, but you cannot make law more lenient. So I want to, let's say there is one point, that I took a example of Tata Trust in my regular class, that let's say there's a point mentioned that in order to change shareholding, approval of Tata Trust is required. let's say there's this point given that in order to change the shareholding or to allot any new shares, or if anybody want to sell their shares, the approval of Tata Trust is required. This is given in the article of, let's say, Tata Sons Private Limited. In the article of Tata Sons, this provision is mentioned. And let's say Ratan Tata wants that this should not be changed. Ordinarily, if I want to alter this provision, can I alter? Yes. This is article now. So can I alter this provision? Yes, I can alter by passing special resolution, because generally for altering article we need to pass special resolution. But we want to make it more strict, more stringent. Can I do so? Yes, I can do so. And we can insert an entrenchment provision in the article. Entrenchment provision. And what is the entrenchment provision? Entrenchment provision is, I can write here that in order to alter regulation number 3, this is regulation number 3 now. So in order to alter regulation number 3, approval of 95% is required. So this is entrenchment provision, which is saying that in order to in order to alter article, SR is not enough. SR is not enough. You have to take 95% approval. This is entrenchment. This is entrenchment. This is entrenchment provision. So can I include entrenchment provision in the article? The answer is yes, I can, because I can make law more strict. So can I include entrenchment provision in my article? The answer is yes, 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 yes. I can include entrenchment provision in my article, which says that in order to alter article, you can lay down more strict condition. That means usually SR is required, usually 75% approval is required. You can lay down more strict condition, more strict, that no, 75% is not enough. If you want to change particular this clause, then you have to take approval of 95%. This is entrenchment provision. This is inserting entrenchment clause in the article. Entrenchment clause says that in order to alter a particular provision of the article, more strict condition have to be complied with. 95% approval have to be taken. 75% approval won't be enough. I hope you are getting what is the meaning of entrenchment provision. Entrenchment provision. And if you want to insert this entrenchment provision in your article, then if you are a public company, you need SR, special resolution, to insert this entrenchment provision in your article. And if you are a private company, then you need unanimous shareholders resolution. Unanimous shareholders resolution, which means approval of all shareholders. Approval of all shareholders. You need approval of all the shareholders in order to add entrenchment provision in the article. So in order to add this entrenchment provision in the article, if you are a public company, you need to pass SR, and if you are a private company, you need 100% approval. 100% approval. All the shareholders approval. All the shareholders approval. In case of public company, 100% approval is not very logical, because in public company the number of shareholders are more, and it's not possible to take the approval of each and every person. That's why in case of public company, SR is required. Private company, all shareholders approval is required in order to add the entrenchment provision in your article. I hope this point is crystal clear to all of you. Entrenchment provision. So come to the book. What is entrenchment provision? That the article may contain the provision for entrenchment to the specific provision that the article may be altered only if the condition that are more restrictive means more strict, only if the conditions that are more strict, in our example 95% approval, right, only if the conditions that are more strict than those applicable in case of SR are met or complied with. This is the entrenchment provision. The language is quite technical, but I hope you understood this properly with the example, right? And basically, very important, this entrenchment provision is for the protection of minority shareholder. This entrenchment provision is for the protection of minority shareholders, so that their rights don't get affected. And this can be made either at the time of formation of the company, or even later on it can be added, later on it can be amended, with the approval of all the shareholders in case of private company, and only with the approval of SR in case of public company. So this is the provision of entrenchment. This is the provision of entrenchment. Let me know quickly if everybody is crystal clear till now. Are we able to properly revise? See, this revision is like a quick revision, and your all the concept will get freshened up in your mind. All the concept will get freshened up, so that if once again you refer this in the textbook, you will be like, "Ha, done. I remember this. Ha, I'm able to understand this." You know, if you'll attend this revision, then just by referring to the book, you will be like, "Ha, I know this topic. Ha, I know this topic. I know this topic. I understand this topic." You don't have to refer each and every line in very detail, right? So this is what, to get freshened up all the topic in your mind. And if you'll refer this once again after this revision lecture, you will be able to recall and remember all the provisions, So just let me know quickly in the chat box if we are crystal clear till now, if we are crystal clear till here. We are almost done with this chapter. Few doctrines are left, like doctrine of ultravirus, doctrine of indoor management, doctrine of constructive notice, and we are almost done. So today we are done with almost 2.5 chapters. That is chapter 1, chapter 3 incorporation, and your MOA and AOA. Half done with MOA AOA. More than half done, I can say. Palak is saying, yes ma'am, everything is getting remembered. Great. Few small points after that today's class will be ended. We'll continue with the remaining provisions tomorrow. So few small points are that there are certain statutory requirement. Your MOA and article should be basically numbered, properly stamped, and it should be signed by the subscriber. It should be signed by the subscriber. It should not be illegal, otherwise it will be ultravirus to the memorandum. What are the contents of article? Very easy, just remember your chapters of company law, your chapters and your topic of company law. That will be content of article. Everything about the issue of shares, about the forfeiture of shares, about buyback, about calls on shares, allotment, transfer, transmission, directors meetings, everything is your content of article. So just remember the chapters of your company law, and you will remember the contents of the article. So there is no much headache to remember this article. Contents of article. There's section 6. I've already explained you section 6. Section 6 lays down the hierarchy, which says that Companies Act is supreme to MOA and AOA. So if there is any inconsistency or fight between MOA, AOA and the Act, then who will win? Companies Act will win. So Act is superior to MOA and AOA, and if at any point of time MOA and AOA is inconsistent to Companies Act, then in such a case MOA AOA will be void. Void. It will not have any effect. So this is the small example. With this we are done with here all the important points. Only few doctrines are left. Doctrines are left which we'll do tomorrow. I am leaving you 10 minutes earlier. See, say thank to me. We started 5 minutes late, so I am basically leaving you 15 minutes earlier. So we are done with today's. Tomorrow what we'll do? Tomorrow we'll continue with this doctrines of this MOA chapter. After that we'll do alteration of MOA, and after that alteration of MOA and AOA, and if after that still time is left, then we can do conversion of business entities. Basically in your ICSI study material, this is one of the last chapter of this part A. In our book it is basically chapter number 8, I guess. So then we will do this remaining provision of MOA, which is doctrines. After that we will do alteration of MOA and AOA, and after that we will do conversion. So this is gonna be a topic of tomorrow. So we'll do this small revision series like for 1 hour 45 minutes or 2 hours per day, and we will be done with your whole SBEC revision in like 20 hours, which will be basically in next 10 to 12 days, 10 to 12 days maximum. We will be done with our SBEC revision very properly, very properly. So I hope that this revision is very helpful for you. If anybody has any doubt till now, then you can surely contact me and ask me over Telegram. I'll surely try to clear your doubts. So with this, we are ending our today's revision series. I'll see you in the tomorrow. No, I'll see you in the company law revision at 7 p.m. See you. Take care. Bye bye.